Welcome to another in the series of videos from Dindinger and Kohler Law Firm. Today we're going to talk about wills and trusts. So Edward, why would we pay for an attorney to make a will for us instead of just doing something like a Rocket Lawyer?
Right. Well, Rocket Lawyer and LegalZoom, they've definitely entered the market, and they are competitors with law firms, especially for this type of form-based law practice, wills, trusts, that type of thing. I think what you get when you hire an attorney is that you get someone who can really delve into your specific situation. I know there is some customizability to the online forms, and that's fine. And maybe if you have a very, very simple estate, maybe no children, something like that, it might be appropriate for you. But I really think having someone that's looking at your affairs in a detailed manner, asking you the right questions, and is familiar with the law of the state. I mean, really, there's no guarantee with Rocket Lawyer or LegalZoom. And the other thing that you get when you hire an attorney is you get the benefit of that attorney's malpractice insurance. Attorneys in Idaho are required to carry malpractice insurance now with a minimum limit of $100,000. At our firm, we carry $1 million of coverage. So if we make a mistake that harms you, you're going to have at least $1 million of coverage to protect you.
So what's the difference between just leaving your assets specifically to different family members versus putting them in a trust?
Yes, so you're talking about the difference between a will and a trust. A will is specifically only becomes effective at the moment of your death, and then it provides for the transfer of those assets. A trust, the way it's normally set up, is you set up a revocable trust in your lifetime. Revocable just means that you can change it. It's also known as a living trust. You set that up during your lifetime. You transfer the assets into the trust. They become trust assets. So legally, they are considered owned by the trust. And then at the moment of your death, we usually set it up so that that revocable trust becomes an irrevocable trust. Now, of course, during the term of your life, having those assets in the trust is not necessarily going to protect them from creditors. Sometimes people sell that as a difference between wills and trusts. It's really not the case. The IRS or any other creditor is going to assume that you're the person in control of those assets, and they're going to be touchable during your lifetime. After your death, that changes. When it changes to an irrevocable trust, those trust assets are not going to be subject to seizure or garnishment because of your personal debts.
So I guess there are some rumors that specific wishes put forth in a will can be overruled by the court after your death. What would be some of those situations?
Well, certainly people can contest the provisions of a will. There's a couple different grounds for contesting a will. They can allege that you did not have the requisite mental capacity to make the will at the time that you made it. Maybe that it wasn't properly executed. They're saying that someone else drew up this will and fraudulently signed your name on it. There's different grounds for contesting the validity of a will. In terms of contesting the specific provisions, they can certainly make those arguments. I think that without contesting the validity, contesting the provisions is going to be hard, unless the provisions themselves are just contrary to law. A lot of times when we are drafting wills, we're actually going to put in a no contest provision that says that if you contest the will, any part of your share is gone. Now, of course, to make that effective, you have to leave them something of value, right? If you leave them $1, well, they really have nothing to lose by contesting the will. So it's really only effective in those scenarios where someone stands to gain and you want to avoid a lengthy will contest fight.
So is there a way for my family after my passing to ignore pieces or aspects of my will? Say if I had specific instructions about my burial, or who gets specific pieces of jewelry or heirloom items or something. Is there a way that my family can overrule what I lay out in my will?
Yeah, I'm reminded of the old Viking funeral question. Can I be sent out to sea on a Viking longboat and have it set afire after I'm dead? There isn't going to be a certain point of reasonableness. I mean, obviously, your will can't require somebody to do something that's contrary to the law. If you live in a place that says you can't be buried in the backyard, I'm sorry that they don't have to follow that provision in your will. But to the extent that it's legal and it's reasonable, they are going to have to follow those provisions. I can't really see a basis. You mentioned jewelry. I can't see a basis for a family member to just ignore what the will says in terms of gifting a certain piece of jewelry to someone that you designate. That would actually be the job, if you have a family member who's holding an asset like that, that would be one of the responsibilities of the personal representative, acting in his capacity on behalf of the estate to go after that person through legal means if necessary, and get that asset to the rightful beneficiary.
So what exactly is an executor and how much do they cost?
Sure. So the executor, in Idaho, we also refer to that as the personal representative. That can be named in your will. It can be a family member. It can be an attorney. It can be just someone you trust. A lot of times people want to name someone very close to them. I usually advise against that because you need somebody who can make rational decisions. And obviously on your passing, the people who are close to you, they're going to be in grief and they may not be in the best frame of mind to handle the responsibility, let alone be rational about it. In terms of cost, if you have an attorney doing it, unless there is some really strange thing going on with the will or a contest to the will, it really should never be more than 3 to 5% of the total estate. Of course, different attorney rates vary. The law does provide that the personal representative, whether attorney or non-attorney, is entitled to reasonable compensation for their efforts on behalf of the estate.
So if you would just briefly talk about how exactly to choose a personal representative and then exactly what we can do proactively to make sure that personal representative has what he or she needs to execute our will the way we want to.
Sure. So, your personal representative, I would say, again, I would not recommend a very close family member, would not generally recommend a spouse or a child, unless there's some compelling reason to do so, because again, your death is going to cause a lot of grief to those close to you, and that person might not be in the best frame of mind to make those impassionate financial and legal decisions that need to be made. On the other hand, you do want someone who knows you. You want somebody who knows kind of your philosophy on life, your relationships with your family and others, and who then could act in your stead in accordance with the way you would have wanted your assets distributed. And someone with some legal training is not a bad idea. Someone with some financial experience is not a bad idea. Lawyers and accountants are often chosen as personal representatives. Really, it is your ultimate decision. I would say that no matter who you choose as your personal representative, keep them updated. If your circumstances change, if your opinions on a family member change or someone else that you were in a close relationship with, so that then they can make those decisions that use their discretion in a way that you would have.
So what happens if a younger couple with children both pass away and then leave their children without a will?
Right, so if both parents pass away contemporaneously at the same time, if they don't have a will, basically it's going to be open for relatives to file guardianship actions to seek to get custody of those children. That's one of the most important things about drafting a will if you do have children, to specifically designate who you would want to take care of your children, and then that doesn't leave it open to a guardianship challenge by your relatives.
So would they go into foster care immediately until somebody filed for guardianship?
I don't see that happening. I don't see a judge ordering them into foster care unless there's some exigent concern about the children's safety or well-being. I would totally see a relative being able to take care of them in the interim. Unless another relative makes a challenge based on grounds of safety or well-being, you would hope that wouldn't happen, but it is a possibility. Just another good reason to have that listed out in your will.
So let's say I don't have any young children anymore. I don't have a surviving spouse, but I have maybe significant debts and assets, significant sentimental possessions, and multiple adult children, but I don't have a will when I pass away. What is like the worst case scenario of what could happen in that kind of a situation?
Well, that's a big question. The bottom line, if I understood you correctly, you're saying that your spouse has predeceased you, or otherwise you die without a spouse, and your children are grown. The law of intestate succession in Idaho, like I said, is that those children are going to be designated as your heirs. They're going to get equal shares of what your estate is. The worst case scenario, I think, just in terms of what the average person would want, and most people are interested in family harmony, is that your children end up fighting each other, and they end up hating each other, as a result of your passing. And I think that's a legacy that no one wants to leave in their family. It's just this legacy of animosity and resentment. So that's one of the main benefits of having a will and doing the estate planning is that you save your family from having to have those hard disagreements, and really there can be some serious ugliness there. So that's just a great reason to have a will and make these decisions ahead of time.
So what if, say, my will is outdated in the sense that I've gained new assets since I created my will, like I started a new business or have different retirement, have got a different job or something like that with new retirement benefits? What happens then?
Right, so the other thing I always put in wills when I draft them is what's called a residue provision. Anything not listed here shall be distributed as follows, or shall be distributed in the discretion of the personal representative. So that would take care of that. I mean, obviously, if you don't specifically name somebody, you don't specifically name somebody. But I would say it's always better to have the personal representative, who presumably is somebody you trust, making that decision rather than a court or just the laws of intestate succession in Idaho, which, just briefly on that, the law in Idaho is that if you die without a will, your spouse, if you have your spouse, that spouse is going to inherit all of your community property and one half of your separate property. Your children will inherit the other half of your separate property. If your spouse is dead, the children get everything.
So let's say I have a will, but it's rather outdated by the time that I finally pass away. For example, like a former spouse is still listed in my will as the primary beneficiary for my assets. What happens in those kinds of cases with a really outdated will?
Well, so when I draft a will, I always put a provision in there that if there is a spouse named, that if a divorce happens between the time of execution of the will and your death, that spouse is automatically written out of the will. I always put that in there. That's because I think it's safe, and that way, you know, if you're in the midst of a divorce, you have enough going on, it's very reasonable to think you might forget about updating your will until down the road.
So for a last scenario here, what if I have no surviving family? I have no living siblings or parents, no spouse, no children, and I pass away without a will. What happens with my estate at that point?
Right, so there are what are referred to as degrees of consanguinity. Those are just your next nearest blood relations. And there's a whole chart, so fills a whole page delineating that. And so it would go to your next nearest blood relations. If those are second cousins, second cousins are going to get it before third cousins, etc., on down the line. And if there is a situation where you don't have anyone that can be identified as a blood relation, I mean, this is such a rare circumstance, almost virtually never happens, but the estate would refer to the state of Idaho.
So just to wrap up, anything else we should know about wills and estate planning here?
Well, a lot of times people will ask about the cost, and of course it's impossible to put a one-size-fits-all cost out there. It's going to depend on the complexity of your estate, the complexity of your wishes, and various other factors. I mean, ballpark, you're looking at anywhere from a few $100s to a couple $1,000s. It just depends. Trusts can be a whole different animal, and we haven't really touched on that in this video. I would say that no matter what it costs to get your will drafted, it's going to be a lot cheaper than the legal battles that can result in the absence of a will, if you have children fighting over an intestate succession, and you really can't put a price on family harmony. So if there's that animosity and resentment that you can avoid, I think it's worth every penny. I would certainly advise all my friends and family to get their wills done and get them done soon. It's always an easy thing to put off. No one wants to think about their own demise, but it's going to happen to all of us. We're all going to be there someday. So it's just one of those things you really should take care of. And we look forward to helping you out here at Dindinger and Kohler. If you want to contact me directly, you can call my direct line at 208-713-8620. Email me, edward@dklawboise.com. And also visit us on the internet, www.dklawboise.com. And we're on Facebook at facebook.com/dklawboise. On a personal note, I'd just like to wish everyone a very happy Easter. Hope it's a very enjoyable and memorable day for you and your family.